In 2016, the Supreme Court struck down key tenets of the Scottish Government's named person scheme. 5 years on, we're speaking to those involved in the successful No to Named Persons campaign and taking a look back at that long road to victory. In this video, I speak to Alison Preuss, co-ordinator of the Scottish Home Education Forum, an early opponent of the scheme. Alison, thank you so much for joining me. Why don't we start by giving a little bit of your background and how you came to be involved with the No to Named Person campaign?
Okay, well, I founded the Scottish Home Education Forum in 1999 and was also a couple of years later involved with the children's rights organisation ARCH, which actually follows the trend for data collection right through until GovFEC came along in Scotland. So we had a huge amount of information that we'd gathered, a lot of history and a lot of substantiation of how the direction of travel was affecting home educators in particular, but other minority groups as well. So we were very keen to be involved in the No to NP campaign when it started out.
We know that a lot of named persons themselves would have been teachers, and so it's quite easy to see how those in mainstream education would have been assigned a named person. It would have been their class teacher or a deputy head or something of that ilk. But how did the system work for those in home education?
Well, it didn't really, which was a problem. We have always been obviously over vigilant about public policy and how it affects home educators, and we were kind of the square peg that didn't fit their round hole, and they couldn't figure out who should be responsible for our children. And obviously our argument was that parents are responsible for their children all along. But we essentially didn't fit into the boxes, so we were perceived as a real problem. And it did come out in the minutes of meetings, which we got by freedom of information requests. So we were seen to be a real problem because we were out of the system and we weren't being constantly subject to surveillance by a professional appointed by the government.
And you had people coming to you before the scheme was even really active in its pilot phase still. What kind of concerns were parents raising with you?
Well, parents were really, really concerned about the data collection, more so than the sharing, actually. We were conscious that parents were having their information trolled and then shared in a kind of profiling exercise, which wasn't actually lawful. And in Highland, I mean, the whole idea had been predicated on a lie that it was about child protection following the Danielle Reid case. Well, having seen this before in England with Every Child Matters and the Victoria Climbié case, which did not give rise to the Every Child Matters data collection agenda, we kind of knew that the same thing was going to be happening in Scotland, and we watched it unfold until the legislation was drafted and introduced to Parliament. So really the lies were spun to suit an agenda that had already been decided, and they were just waiting for the right vehicle to come along, and child protection happened to be it. And it was really sort of, it was unfair, it was untrue, and it allowed parents to be bullied into doing what professionals wanted them to do to meet their government outcomes, which are not the same as exercising rights at all.
Possibly the biggest concern about the whole named person scheme was really this sharing and trawling of data about children and families without consent. Why is it such a problem?
Well, it's a real problem because it actually morphed from child protection, where information can be shared, and no one ever had any problem with that. It was never contended in the court case or anywhere else, despite rumours to the contrary. It was they casually shifted the threshold for sharing information from child protection, significant harm, down to well-being, which was completely undefined, very vague, and honestly could be made up. Any professional could make up a well-being concern about anything at all. And naturally, as home educators, only the other week we had a professional announcing that home education was a red flag. I mean, it just isn't. It's an equal status choice within education. So the issue really was the lowering of the threshold, and the public at large were not aware of the implications of this at all.
But it wasn't just children being monitored, was it? There was information being taken down about the parents as well.
Absolutely. That was part of what we had discovered way back in the early 2000s in England, in that information was being collected about parents and other third parties and other adults connected with a child. So really, it covers almost everybody in the country, because most people have some sort of association with the child. So this information was being collected on a just-in-case basis. It was never legal, and we know that case law has since decided that. So what we were having was a profiling agenda, and in a way to seek to prevent future harm or future delinquents. And the famous Tony Blair video, which says, we're trying to find delinquents in the womb. I mean, that's exactly what it was.
So you were obviously very concerned about all these things that are going on, and you joined the No to Name Persons campaign. What was involved in that? What did you do?
Well, it was interesting. It's probably been a blueprint for future activism and future campaigns, because it really was a first, in that people had shared their concerns within the consultations on the bill as it was going through Parliament. And it was quite easy to identify those who shared the same concerns. So we were very, very keen to be involved in a coalition of interests. People who have come from very different backgrounds and very different ideas about other things, but we shared these deep concerns about children and families being profiled and being sent down government well-being paths that they maybe didn't really want to go down, and having the rights trampled on, in favour of them being forced to comply with government outcomes. So we were really quite happy to be contacted and to become involved at a very early stage. And, we felt that we had a lot of information at our fingertips from the history that would be useful to the campaign.
And you spoke out during public meetings as well, didn't you? And I'm sure there would have been opposition from people attending those meetings, well-meaning people who say, we have to do this, we need to protect vulnerable children, so this is a great idea. Now, we'd all agree that vulnerable children need protection, but was this the way to do it?
Well, yes. The public meetings were very interesting. They started sort of fairly slowly with few numbers, and then by the end there were huge audiences. I tended to share a platform with Leslie Scott, and we were quite the double act, really. There was audience participation clearly at these meetings, and some people, professionals and members of the public, were very, very concerned that this was anti-child protection, and that we didn't believe that children should be protected, and from extremism and abuse and all the rest of it. But once it was very patiently explained to them about the threshold and why it existed, what the case law said, and why well-being was not the appropriate threshold, when it could be, it could mean anything at all to anybody and was completely subjective. People did tend to come on side. We had a few sort of completely intransigent individuals, but that was fine, because we knew it was going through court, and we were quite confident that it would we would be vindicated by the Supreme Court.
It's been said, I believe it's a line that's been used at these named person roadshows, that if every child is so vulnerable that they need a named person other than their parent, there's an assumption that every parent is going to be negligent in the way they raise their children. You would agree with that sentiment, presumably?
Well, it was ridiculous, because parents had suddenly become the enemy, and we saw the government gaffes kept us entertained for years on end, frankly. They kept coming up with all sorts of things. One example was the Gerfik Cluedo, where it was always the parent what done it, in the home, and they killed their child or abused their child. But the government excuses kept changing according to what was required. Whether it was a gaffe, they needed an excuse to call it child protection when it was, about parents, killing their kids. Or when parents did kill their kids, it wasn't Gerfik's fault, because that was way beyond well-being. So they couldn't ever get their story straight, and nobody seemed to sort of accept that the named persons who were professionals were very often parents themselves, and they were not allowed to be the named person for their own child. It was Stasi-like, and we did coin the McStasi sort of expression out this, because it was just utterly ridiculous that nobody could be trusted, and that was the way the government were going about public policy in terms of child welfare and well-being. Leslie and I had special concerns about the regulators failing to regulate. The Information Commissioner, or the Assistant Scottish Information Commissioner at the time, was quite happy to side with the government to suit their policy, in that he unilaterally decided that he could reinterpret the law to lower the threshold to well-being or to anything that may lead to child protection, but no evidence existed. So we had real concerns about that, because he had already allowed for the Police Scotland to set up a vulnerable persons database on the same basis, in that every child was vulnerable, so they all had to be on this database as being vulnerable. That was just nonsense. And in fact, the government's GIRFEC team relied on ICO advice to send out a memo, essentially, to say that you can share information at the level of well-being on the basis of gut feeling, because the Information Commissioner says that you can. The Information Commissioner had clearly missed the High Court judgment in March 2013 in Haringey that determined that the threshold was significant harm, and that you couldn't just go off and do your own thing and arbitrarily interfere in family life. So Home Educators actually instructed the solicitor who dealt with that case to submit our response to one of the early consultations on the bill, and he essentially predicted the outcome of the Supreme Court judgment.
Eventually, though, the campaign was a success, a big win in the Supreme Court. How did that feel?
That was great. I mean, that's a day that's etched on my memory. It was wonderful actually being at the Supreme Court and hearing the judgment being delivered right there and then. I didn't know what the outcome was going to be when I got there. I didn't know. Some of the others did. So it was a massive relief, and a great deal of euphoria among our supporters outside and elsewhere. So it was a wonderful experience to go through that process, and to know that it has led to others being able to do the same thing, to challenge a policy which is unfair and unlawful, and to receive that determination by the highest court in the land.
Alison, thank you for joining me.